You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh?
I'm not gonna call
Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
Got it?
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge, they don't know they missing. Got a couple current events that you like, wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
What's up, y'all? Happy Saturday. Thank you for everybody that is coming through today. Shout out to my son. He did that intro. That's him rapping, my oldest son. Yeah, he sent it to me for my birthday. And I thought you guys could hear that on today. We have a lot to discuss. I've been trying to do this transcript since last Friday. So today I'm waiting on my co-consuls to come and they're going to join us. You guys know Thais and Really B. They'll be in the house in a few minutes. I think we got one of them here. Let's see. Wait a minute. Really B is in the house.
Hey, I like my intro. I was back here grooving. I said, okay, son. I didn't son, but I was like, okay, yes.
Yeah, that's my oldest son. He did it for my birthday last month.
That was nice.
Yeah. So yes. We're just waiting on Thais, but we have the reading of the transcript today. So many of you guys have been keeping up with the Glory of God situation with me, and we kind of touched on the March 9th hearing. However, I was saving the actual verbatim words for this transcript reading that we are going to do. So I'm excited. I'm excited. We got to give out our parts though, because
Now that slid on the banana peel. Be careful now. They're trying to run in and get a good seat. It's plenty of seats down front.
Right. Bring her to the front. She's loyal.
Please bring her to the front. That's right. Urshas. Bring her down
All
to the
right,
front.
we got Thais for the Thais report.
Hey, I'm here.
So now, Thais, I'm going to give, just because we had so many new people, and some people I'm sure will be piling in. I don't want to have to repeat this transcript all over again because it's 54 pages. We're not going to go through all 54. Thais to put on his bishop grease.
Not the bishop grease.
Stop, y'all. Stop.
Oh, God. We're not going to go through all the pages. I'm going to highlight certain spots, okay? So, who wants to be Bishop Lamar Whitehead in this transcript?
I can do it.
I'm about to say Thais got to do it.
Watch this. Ah, wait a minute. Watch this right here. 10 toes down.
That's what I was waiting for. I was waiting for 10 toes. I was waiting for 10 toes down.
I can do it.
All right. Who wants to be Brian Ponder?
Oh Lord, I guess I'll be Brian Ponder.
I'm gonna be the court, and I'll be the we got two more people. We have Gloria, God's attorney, and then we also have Moses' attorney. But Moses' attorney don't really say much, but he does have a few,
Okay, I can do Moses' attorney. Let me know the name. I can do.
Okay, it's Kolak. So Thais, you can do the Gloria God. Yeah, Gloria God's attorney. It has a lot of parts, but yeah, I'm just waiting till we get to Whitehead when he gotta address your honor.
Okay, so I'm doing Whitehead and Gloria God's attorney.
Yeah.
Okay, what's the Gloria God's attorney's name?
That lady's name Clover Barrett.
Okay.
Okay.
Yeah.
As long as it's not the guy from last time that had to keep saying his name over and over again.
Oh my God, sir, we know.
They have a new trustee. It's a woman. It's not him. So
okay.
So he's not saying it. But just briefly before we get started, just so everybody is on the same page, Glory of God was the church that you currently see Whitehead in, if you guys follow him, is the church that Glory of God has occupied since 2014. If you look back at the history, Whitehead tried to, the building went up for foreclosure and a tax sale. Whitehead alleges that he is the trustee for that building that's in a trust. He went on behalf of the trust back in September to try to evict Glory of God. The court said, no, we're not doing that. That was in September. In December, Whitehead comes along with the NYPD and some of his homeboys. And the court, this is all according to what we're being told. Of course, we weren't there. And basically removes the locks off the building. So then Gloria God files a wrongful eviction and asks for treble damages and a legal eviction, and they win. That was December 21st of 2022, around that time. Might be off on a few dates. Then Whitehead was like, I still ain't going nowhere despite this order. So what he does then is, in January, they do an order to show cause why he shouldn't be held in contempt, basically for not complying with this order. So they went again, and Whitehead is told, give these folks their building back by 5 o'clock. So Whitehead goes and says, what do I do? What do I do? What do I do? What do I do? And he goes and files for bankruptcy. When you file for bankruptcy, it stays all proceedings, even landlord-tenant type proceedings. So the order basically stayed everything. There's an automatic stay. What we learned, so all of this stuff that we're going to do right now in the transcript is from the bankruptcy court. So a lot of stuff is happening in bankruptcy. In February sometime, which we didn't know until I didn't know till this hearing, actually, Whitehead got another attorney. It's not Ponder, a whole nother attorney, goes to landlord tenant on the commercial side and tries to file a whole nother eviction even after he filed the bankruptcy. So what we're going to do is we're going to start from when Glory of God's attorney addresses the court about him filing this February action in the landlord-tenant court of the commercial building. So that's where we gonna start at. Y'all got it? Y'all with me, co-counsel?
Mm-hmm.
Okay.
Mm-hmm.
Just making sure. I know this stuff is
child, it's so convoluted.
All right. Why isn't this big?
Okay, now I'm Gloria God attorney, and who else? I done forgot that quick, Lord.
I'm Gloria God's attorney.
No, you're who did you say you were Ponder?
How can I forget I'm Mr. Ponder, Lord Jesus?
All right, let's go. We're gonna start on page 18 because this is when, just for the audience to know, we are discussing this February filing that happened during the bankruptcy proceeding. Okay. And we'll pause a little bit every now and then because we don't want people to get confused because this is confusing. Yes.
Please hit that like button while we getting ourselves situated. Come on in, take a seat, hit the like button, please.
Yes, please. And subscribe if you haven't done so. I didn't even throw that out there.
Absolutely. I'm about to get this good church stage play on a Saturday afternoon.
Listen.
Mama, I want to sing.
Right. Part 2.
Everybody got their CarMax on? Let's get it, Miss Barrett, right there.
That's me.
Miss Barrett?
No,
that's Gloria God. That's you, Thais.
Oh.
Okay. Okay. So, Your Honor, I have one more observation.
Sure.
Okay, scroll. You got to scroll, Pam.
Try to scroll more.
Okay, my computer's a little bit behind yours, so let me go over here.
Oh, wait a minute, because I'm like, it's gonna go past it on the screen.
Okay, wait a minute. Let me go. My computer's a little bit beyond yours, so I better go over here to this device. Oh, this is perfect. Okay. Miss Barrett. Okay, it's something I'm concerned with. So on day 1, at the first hearing on the old case, Your Honor, was clear to the debtor that they can't use the bankruptcy court as a sword and shield, meaning that they can't have an automatic against inaudible. Okay, so against Gloria God. And that's exactly what they did. They have served a notice, a 10-day notice to quit on February 5th. It was signed by Lamar Whitehead as trustee, and I have actually spoken to the retained counsel for Lamar Whitehead, the trustee, well, the listed trustee, but 5904 Foster Avenue, Carl Husbands, who is representing Mr. Whitehead, is the landlord and tenant. And he has confirmed to me that after the notice to quit, which was filed after the bankruptcy was before the dismissal, that he had actually requested.
And for y'all to know, there's going to be a lot of inaudibles because this was on Zoom. So when the court reporter was probably trying to pick stuff up, there's a lot of delays on Zoom. That's one of the bad things about Zoom is you'll have a lot of delays like we have on here when we talk over each other. Well, go ahead, Thais.
How it works and landlord and tenant, once a 10-day notice to quit is served, then you go ahead and you request a petition number and then you get it served. I want the court to make it clear to the debtor again, if they didn't know that they cannot do this because that is unfair. I think what Your Honor said to them that, honey, I'm not trying to act like I'm a Rhodes Scholar or not, y'all, but sometimes verb noun agreement, I read it as it's, you
read it correctly.
Yeah. Okay.
And that's
I know these are smart. I know these are smart people, but some of this verb noun agreement is not really adding up.
And I'm watching you do it. I was like, this is probably killing him right now. He like,
yeah, these are supposed to be really smart people. Okay, here we go though. I think what Your Honor said to them then, if they want to proceed against Gloria God, then you would be.
Am I too far down? I done lost.
No, that you would be constrained to lift the automatic stay, and I'm very concerned about that. How it works in landlord and tenant. Okay, wait a minute. Did you scroll too far, Pam?
You already finished, right? Oh, I'm very.
I already finished. Okay, well, go ahead, then. Remember, y'all, this is not we're not on Broadway. This is Tyler Perry live at the Fox Theater, y'all.
And scene. That's a legitimate concern, all right? So let's just put that issue. Mr. Ponder, you can't have it both ways. Your client, if your client is going to proceed with the state court action to dispossess Gloria God for whatever that is, I'm not even sure if they are, but if they're if the debtor is going to do that, then Gloria God has to have the opportunity to defend itself in state court. Listen, I'm not saying I know what the party is telling me, and that's it. But I will of course entertain the motion on an emergency relief if there were to be the case. Do you have a concern about that or response to that, Mr. Ponder?
Yes, Your Honor. So, and if Glory wants to bring a motion with respect to that, I'm ready to brief the court. But the debtor, look, I'm going to talk about it. I'm just saying I'm not glory to their positions, better to this position, but the debtor has the right to conduct post-petition litigation without a need to lift the stay, and likewise.
That's not true. That's just not true.
Okay. All right, Pam.
That's not true.
Okay.
Pam turned into a little Cicely Tyson.
The automatic stay applies to all causes of action that belong to the estate. The debtor needs to get bankruptcy court approval before commencing post-petition litigation on a pre-petition claim because it's past the estate. So even a debtor is not permitted to litigate and assert pre-petition claims and pre-petition causes of action without this bankruptcy court's approval, number one. That's besides the point. And I'll excuse your ignorance of that, but fair play. You're in a court of equity. You are before me asking me to vacate a dismissal order when the debtor didn't file schedules, show up for the 341 meeting, is in contempt of an order, hasn't provided proof of insurance, and hasn't provided a DIP account. All right. So in this court, we don't engage in sharp practice. We act fairly. All right. So number one, on a legal basis, you're just wrong. Number two, as a matter of equity, you're wrong. And that will not, by this court, and I apologize for raising my voice, but it's considering the position of the debtor today.
Again, I just hate to sound like the debtor's position is not the debtor's position and that they are asserting any pre-petition claims, post-petition litigation. And again, if the opportunity comes before the court, I will brief the court. But again, I don't want to, just in response off the cuff to Miss Barrett's concerns.
So let's be clear.
Brief the court.
Let's be clear. I'm interrupting you. If the debtor's position is that the debtor is enforcing a post-petition claim, then I will tell you the Gloria God's response will not be stayed.
And that's what I expect, Your Honor. So to be clear, any post-petition claims, it is the debtor's understanding that Gloria of God will be able to withstand such a post-petition claim and does not require a lift of automatic stay with regard to pre-petition claims. So that's the debtor's position that Glory, if it's the defendant, would not be stayed from defending itself in such post-petition litigation that's legal. In legal post-petition litigation. I don't know what the hell I'm talking about.
All right. So my expectation will be that, well, first of all, there will be, if anybody seeks damages for violations of the automatic stay, but also to give comfort, I think a request, if Gloria God requests a stipulation that the debtor does not object to Gloria God defending itself, I think that would be appropriate.
Certainly, Your Honor.
All right.
We would not be trying to tie their hands from defending in a post-petition litigation at all.
Okay, so let's stop here, guys. So what I want, because I don't want y'all to be lost, because even my co-consuls look a little confused
Child.
too.
I don't know what the hell I just said.
It's all this repetition, and how many times is he gonna say again? Okay.
So what happened is this. So I told you that Whitehead filed a petition trying to do a whole nother landlord tenant while this bankruptcy is going. So the way the bank, all you gotta do is do research. I told y'all I don't practice in New York, but I was able to at least find the cases where it'll tell you. For instance, right here, any proceedings or actions described in section 362A1 are void and without vitality if they occur after the automatic stay takes effect. This includes post-petition judicial actions. Although ministerial court actions are accepted. Although an action in violation of the stay is void, the bankruptcy court has the power to validate it. Congress has declared that actions to terminate, annul, or modify the automatic stays are core bankruptcy proceedings. So basically, based on the law, and again, all you had to do was just Google just a little bit. It wasn't even that deep to find out what the law is on post-petition claims. What they mean by post-petition is him filing this complaint with the landlord tenant or filing any type of action while this stay is in place. So basically, according to the law, it's void because everything you do, you have to ask the bankruptcy court. Now, the bankruptcy can say, okay, we'll accept that order, but you got to go to the bankruptcy court. You can't have it both ways. Like, I want to stay the orders of the pre-orders that are already there from Gloria God, but then I'm just gonna do post petition and do a whole nother type of an action and then try to kick them out. You see what I'm saying? Like they're trying to do both ways. Okay, so it didn't work before. So what I'm gonna do now? We're in bankruptcy. Their stuff is gonna be stayed. I'm gonna file a whole nother action and try to kick them out while the bankruptcy hearing is going. So it almost sounds like you filed the bankruptcy just to hold it off until you can do little other stuff on the side. In my opinion, see if you can get it done, but wasn't really necessarily anticipating or whatever to continue on through the bankruptcy to the end. That's just my opinion. Of course, I'm not in the case and I don't practice in New York. But this is a case from New York, and they basically let you know for anybody that wants to know how the automatic stay works. So that's what's going on. Yeah, that's what's going on with that actual case that he filed in February. So that was the back and forth that you guys went to because they being Whitehead actually filed a whole new he filed a whole new eviction in February and tried to evict them after he already filed the bankruptcy. But according to case law, it's void. It don't mean anything because you're still everything is stayed. Post-conviction, pre-conviction, whatever. I mean, post-conviction, Jesus. Post-petition, pre-petition, it's all stayed. So
Ponder he's like the evil Knievel of law. He's the most risk-taking attorney that I have ever seen in my life. Was he a stunt man in earlier years?
What I got from that transcript, I don't think he know. Like I say what I don't know. I don't know everything. So I don't know bankruptcy. I can look it up because I know how to research. I'm a great researcher. Now I found the answer. But I try to hone in on my craft that I do on a daily basis. I don't try to just muddy it up with every single area of law because you'll never get the grasp and the grip to learn an area and teach other people that's coming under you. You know what I'm saying? Because you never really grasp it. You got your hands on everything. The way it sounded, it was clear he really didn't know what was going on. To me, that's what it sounded like. Because it was almost like she was teaching them how the law goes when it comes to those stays. So I'm a fast forward check because they talk about this for a little minute, and it was pretty convoluted.
So he just throws things against the wall, Pam, and just sees what sticks.
That's what it looked like in this bankruptcy court. And then you'll see how they kind of ask the judge. So we're gonna go. So when it comes to this same issue, Whitehead asked, can he talk? So they talk about this for a while. And the reason why I went past the first part, it was basically about scheduling. So you guys know there is a hearing coming up next week at the bankruptcy court. It's an evidentiary hearing, and there's certain dates for them to file their witness list, discovery, all of that. So the first probably 30 minutes was about scheduling. So that's why I went straight to that issue. And then let me go down to Whitehead because shit.
What day will they be discussing them signatures? That's the day I want to take off for myself. What day is that gonna be, Pam?
Oh, I'll be there. I'll be there.
Okay. I'm gonna clear my schedule that day.
I'll be there. I'll go live on everybody's platform on that day. So yeah, they're gonna be on back about. Okay. So no, I don't want to do that one. Oh, okay. So the court. Okay, Mr. Ponder, is there anything else that you wanted to ask me to clarify?
I don't see it. Where I don't see. Oh, I can't client, but the debtor itself did have some questions that the court will hear issues that the debtor has.
Mr. Whitehead, go ahead.
Okay, so that's blacked out. That's him. Okay, I
Yeah,
see.
that's him.
How you doing, Your Honor? How you doing, Your Honor?
I'm well, thank you. How are you?
I'm doing great. I'm doing great. Thank you so much. Okay, there we go. Really quickly. I was just a little confused at some of the things that you spoke about so that I can have an educated conversation with my attorney. I just want to be clear. Watch this. I just want to be I'm sorry, y'all. Watch this. I just want to be clear that what I hear, and then he gives me legal advice, which we need to do. Okay? I need to be clear from what I hear, and then he gives me legal advice, which we need to. I can't do this, Pam. This is like, come on, y'all. Some of y'all, I know some of y'all can do. This is bad. This is bad grammar. I'm sorry. And I read it the way it's written. Okay. But I'm going to go ahead. Okay. Wait a minute. This is bad. Okay. I'm a public school victim too, but damn. Okay. Here we go.
Not the miseducation system.
Right.
Yeah. About the miseducation of Lauryn Hill, the miseducation of Thais Jackson. Okay. So first, okay, where we at, Pam? Are we okay. Okay, so first, I want to let you guys know that, and let the court know that, you know, we're not malicious, and I was very concerned and upset at what happened to my attorney's mom. However, you know, it just means that it just means that it's a little A, and I'm just.
You're going to have to slow down, Thais, with this type of language.
Okay. Oh my God. Okay. It's just. Okay. Just seems that it's a little A, and I'm just tell you, it's me just being legally ignorant. It just seems like a complete ambush. You know, he loves explosive words. Ambush. Okay. It seems like a complete ambush on, you know, the dismissal of the case and all of the different things that, you know, and then the scheduling and all the things that have to be addressed. But due to the fact of such a treacherous situation, it really put, you know, myself in a very compromising place. But what I wanted to say to you, Your Honor, is thank you for the time. However, I just need clarity of what you explained. Why do you need clarity about what she just explained it? What did she got to say it over for? Did she have to break it down for you? Why she gotta say it over and over again? She just said it. Oh, okay. Anyways, explain about. So therefore, we are not offending the court. Well, you're offending me, and I'm just an actor in a play. Okay. So therefore, we're not offending the court, but it was to my understanding that we're not using the federal bankruptcy procedures to use it as a sword, as Miss Barrett so kindly stated to you, and under the advice of my attorney, stated to you, so kindly stated to you, and under the advice of my attorney, stated that we were able to continue to move forward with any landlord tenant actions unless it oh girl, you know, he does that. Okay, he does that.
What he's trying to do, y'all, is he's trying to, what I just explained to y'all, what he got out of the judge is that she was saying, yeah, if you file it, we're not going to tie Gloria God's hand. So if you file it, you can't try to say, well, there's a stay so they can't respond. She said, I'll allow you to respond, you know, Gloria God to respond if they need to. Their hands aren't going to be tied. So he's trying to come back to get some type of clarity to see if it was okay for him to go ahead and proceed with this action that he filed in the commercial landlord tenant. So that's why he came back on, because he knew his attorney wasn't really getting it, was trying to get clarity. So he's trying to figure out if it's okay for him to proceed or if he'll be getting in trouble for it. So he said he want clarity, but
they're Googling in real life.
Right.
Okay. It bothers me what was already stated. So I just wanted you to explain. I'm not trying to change everyone's mind, but I just listen, Greasy. All of that slick talk don't walk. Is this a woman judge, Pam?
Mm-hmm.
Yeah, all of that don't, you know, he's trying to, you know, caress. That don't work with every woman. Okay. Okay, let me get back into play. Okay. So I just want you to explain. I'm not trying to change anyone's mind, but I just want you to explain, Your Honor, if you can. Again, if you can't, then I'll just talk to my attorney. But you had got really upset, and I don't want to be in any way disrespectful to the court, and I don't in any way want to be agitation to the courts, so I can have a conversation with my attorney, a competent conversation. I just want to hear from your mouth, because I was confused. There's so many things going on, and then Miss Barrett jumped in, then my attorney jumped in, and it became a lot convoluted. So I just want to say we're not trying glory of God's, we're not tying glory of God's hands on defending themselves from anything, you know. So if you can just explain to me and put clarity on what you spoke about with that, and please not get, did he ask the judge not to get upset?
He did.
Oh, okay, that's what's up. Not to get upset with me. I'm just very legally ignorant. You think? And I just want to have a competent conversation with my attorney. Thank you, Your Honor. Whew, Jesus, I feel like I've lost 45 brain cells.
Thank you, Bishop Whitehead. Your question is taken in the spirit it's intended, which is just to obtain clarity and to present the debtor in, even though I don't rule on my feelings, I rule in the law. But I think what you said really answers the question, and what you said and what your attorney said is that if the debtor proceeds to try to dispossess Gloria God and to take action in furtherance of his 10-day notice to quit, and Gloria God takes action to defend itself and state where the debtor isn't going to come back and say Gloria God violated the automatic stay. That's what it's all about. Regardless of how you characterize whether this is a post-petition claim or a pre-petition claim, if reasonable people can disagree, I just need for there to be to clarity that if the debtor feels that this is a post-petition claim that it can prosecute without bankruptcy court approval, okay, be prepared. People may disagree, but also that if the debtor takes action based on its belief, that may be fine, but then it can't come back here and complain that Glory of God is defending itself. That's it, a level playing field. If you're going to go litigate in the state court, Glory of God can appear and do whatever it needs to do in state court. So what the court was basically letting them know is like the case law we went over. You don't file it and think that I'm just going to allow Glory of God to have to sit back and not respond to your filings because you filed this bankruptcy. And obviously their response is probably going to be to dismiss this joint. Or they can bring up the law we just talked about. It's so many defenses to this that I think the judge isn't even really concerned about whether they file it or not, because it is so many defenses. But in theory, you're supposed to ask the judge for permission in order to do any filings. Because again, as we've seen in the case law, it's almost automatically void if you file going during bankruptcy. I know way too much about bankruptcy now that I really didn't want to know. Trying to help y'all so we wouldn't be reading this stuff looking crazy. Like, what does this mean?
We can't sound no more crazier than these two idiots.
Glory of God, when y'all get this church back, I'm gonna need y'all to close the doors, lock the windows, don't let nobody in.
Okay.
Don't even open the door when we get y'all this church back. Close the doors, close the windows.
We working hard over here.
Ooh, Jesus.
So you want me to do the next Whitehead? You sounded like it was about it. I'm about to switch up and you gonna be the court in a minute. She don't even.
Okay, Your Honor. Your Honor, just one thing. I'm clear now. He got to clear that quick, Pam.
He did. That's what he said.
Okay. Your Honor, just one thing. I'm clear now, but you just stated, and I should have just kind of asked you to explain it, but I just want to know, are you just pretty much stating that, we're not violating any stays on our behalf? The only way we are violating that is if we come to the court and say that Glory of God cannot defend themselves.
I don't take advisory rulings at all, so everybody proceeds at their own risk. If you're going to litigate stuff in state court, then you either have to ask permission from the bankruptcy court or proceed at your own risk. And maybe there is no risk. I don't know. I haven't looked at your complaint or what's happening there. I can't speak to that. I wanted to explain to you that my feelings were because you seem to care about how I feel, and it looks like you want to try to do the right thing here, and I appreciate that. I guess my suggestion would be, to talk to your attorney. So he's a very capable attorney, and
so, Your Honor,
work it out.
Your Honor, can I ask you?
No.
You can't ask me nothing.
Oh, wow.
You ask these questions to Glory of God.
Lord have mercy.
Look at him. No, he's trying to get clear. I just want to make sure if what I'm doing is legal or it ain't legal, or how did this go. That is definitely a conversation you have with your own attorney to figure out what the best way to proceed is. Both attorneys, because you have a whole nother one on that case, a different one. Whew, go ahead.
Okay, it says the court.
Oh, wait a minute. No, it's on you.
Okay, my phone is it back live? It's live.
Can I have 2 minutes with my attorney? It should be at the top.
Okay. Can I have 2 minutes with my attorney before I ask you that? Are you saying that we make an oral application towards what you're saying to ask you for permission? So if I can ask my attorney, does he think that this is a good idea to do it? Then, therefore, we are in compliance with the courts. My thing is, I do not want the courts agitated or think that by any stretch of anyone's imagination that that we are malicious towards glory of God or anyone that is a part of this bankruptcy.
First
Or
of all,
anyone that is a part of this bankruptcy.
You went in December and cut off locks of a church. After you knew in September you didn't have the permission to do so. Then you filed this bankruptcy in response to orders. But you're talking to the court. See, this is why I was saying before, it's not like the judges really know who he is. You know what I'm saying? They don't know. They probably don't know what happened in state court. They probably don't know about other cases. They probably ain't paying any attention. It's a bankruptcy court judge. You know what I'm saying? So the way he talks, I can tell how he is in court. That's what I was explaining before. I said, I think he goes to court. He knows how to have a conversation. In family court, he probably be crying. I'm telling you, because that's what touches folks' heart. In this court, is he seen that the judge was kind of getting a little hyper when it came to his attorney because of him not knowing certain things or whatnot, or saying that it was okay for the post-petition eviction. So now he comes back and he's like, Your Honor, I really don't mean to be malicious. I'm just ignorant of the law. You ignorant of the law? Do you know how many pro se stuff you done filed in court? Like, how many cases you got going on for you to be ignorant of the law? So you come across, ignorance of the law is no excuse. That's what they would have said here. So, but nevertheless, so now you come and you're like, I just don't want you agitated. I don't want to do anything that violate. So then you see the judge was like, you seem like you're trying to do the right thing. So I have to respect that. You see what I'm saying? Like, gauge what's going on in the moment. And then you try to go, you know what I'm saying? But when you lose control, when he loses any type of control, y'all already know what's going to happen if he loses control. We already seen it.
You's a clown. That's what you. Why don't you call me a cardboard bishop now? Huh? You tough? Call me a cardboard bishop now.
He's not gonna call you that.
Huh? Look on Facebook Live. Call me a cardboard bishop now. You clown. That's what you are. You clown. That's what you are. Why don't you say what you say on Facebook Live, sucker?
No.
See?
I would have said in LA, I would have told him use the cardboard bishop. I said it would mean.
He thought he had the right answer in that moment where they gave him the paper and they served him, and he was like, "You ain't you." He said, "I ain't been served." Yes, you have, because I'm serving you now, brother. You a clown. You know, because the control is gone. You know what I'm saying? So if that's what happened when we go over the transcript for his sentencing, which we'll try to do sometime next week if my co-counsels are free. But that's the similar is I see, like I can tell because I've been in so many court settings, I can tell how he is in court. So you see, he's like, oh dang, she done pissed my lawyer off. So let me get on here so it's not a representation of, I don't want it to seem like it's a representation of me. I'm doing all I can to follow all the laws and the procedures. When all we gotta do is Google your name. But these judges don't know. And that's what I was saying with the landlord-tenant court. I was shocked because y'all in the same building. It's just a different department, perhaps. So how didn't you know that there was already an order that was entered in favor of glory of God before you even set some type of hearing for this whole eviction for this one he filed in February? It's just it's all over the case. It's so many things going on. It's almost like it seems like it's on purpose. Like I'm just gonna have all this convoluted stuff going on, so something's gonna get lost in the sauce. Somebody's gonna miss out on something, and then bam, I'm about to get that joint on a technicality.
Crazy.
But yeah. Anyway, let's go ahead on the I think it's on me. All right, thank you. I don't usually entertain substantive applications orally because what he was asking is, since the judge said you got to seek permission in order to file. Now, you done already filed, but you done already gave them a 10-day notice. You did all this stuff already. But you're saying, well, if you're saying all I got to do is ask permission, can we orally on the record right now as we speak, ask for permission? So the court said, all right, thank you. I don't usually entertain substantive applications orally. I never know what's going to come out and what people I do like. If you want to make a motion or want something, to make a motion, file it on the docket. If you need expedited relief, then file the local rules, make an affidavit, file an affidavit that says why you need expedited relief and a hearing on short notice, and I'll do it then. I also, frankly, just as I guess it's the practitioner coming out of me, I'm just a little uncomfortable having anything decided on a conversation with counsel. I'm just going to say, go back, figure it out. If you need emergency relief, you know where to find us. Follow the local rules, all right? Does that answer your question?
Is that right here? Oh, okay.
Yes, ma'am. Thank you so much. Thank you, Your Honor. Thank you. Thank you.
All right.
Yeah.
And scene. So that includes that. That concludes that whole scene.
Child. Can you
He's
imagine?
doing all of it. It's like you doing all of this for a church with 3 members. Like it's unbelievable.
Yeah. So we're gonna go in the chat before we go to our last little ending, because that should make us go into the into our hour. I'll try to keep it within an hour. Did y'all see any type of any questions you guys seen that you want to answer? Jessica said legally ignorant, biblically ignorant, financially ignorant.
Damn, Jessica.
Well, dang.
All right, Jessica.
How
Jessica,
you really feel?
Right, Jessica with a K. You better let them know.
Toria said exactly, Ty. Lock them doors. Lock them doors. Put you a couple dogs in there. Chain them,
baby. And don't sign nothing else. Don't sign nothing. No. If certified mail come, don't even sign for it.
Nothing.
And if somebody looks like a process server, turn around. If they look like they serving something, just turn around. You don't even see them, and you don't live there, and that ain't you.
Okay. When I say I want to be a fly on the wall next week, Lord have mercy.
Somebody said the court system is so archaic and slow. Sometimes it just feels like y'all just allowing so much to slip through the cracks with people like Whitehead, of course.
Yeah, because again, what if they never found, like, say for instance, he filed this landlord-tenant situation and Gloria God never saw it. Mm-hmm. What if he would have got a default against them? So then that default would occur, even though he don't know it wouldn't have meant nothing, because the bankruptcy court could have avoided it under the law, according to the case law. But what if then you would have used that order in order to proceed, and then you probably would have dropped the whole bankruptcy?
Wow.
You know what I'm saying? Because you got all this stuff going on. They still got the landlord-tenant case. Then you just filed a landlord-tenant in commercial. There's 2 bankruptcy cases going, because y'all know he filed the bankruptcy, then it got dismissed, and then he refiled the bankruptcy in order to stay it again.
So there's no cross-checking ban, right? Landlord-tenant court, bankruptcy court, small claims court. There's no system in place that can catch filings.
Well, here in my state, in Michigan, you have to put on the complaint whether there's independent actions, or if that's similar to this case or related to this case, or somehow should be combined with this case because they want you to go to the same judge, or if there's a prior action that was, like, before you even start your complaint, you have to put that on there. If there's a prior action that's similar to this case, related to this case, or whatever, you have to put that case number on there. So there's cross-checking a lot here. I don't know what they do there in New York. I've never seen anything like that. But I just can't imagine. I can totally see him people just not wanting to be bothered because you're just going to drag people in court. Everybody don't want to be in court all the time like me. No.
How is he even able to do this when
you can't ask the judge for legal advice. That is true. That is true. That's why I said he tried to make it like I just want clarity on what you just said. But really, in theory, she was kind of training them and letting them know, no, what you're saying is not true. Because he was like, this is a post petition, so I can do it. Judge was like, no, you can't. You can't do it. You're in bankruptcy. Either you have a stay or you don't have a stay. And if you have a stay, you got to ask our permission before that, before you file anything.
This is it's just never ending, Pam. We could do one of these plays once a week, twice a week, and never do the same play over.
Listen, that's why I said for real, if we go through like his sentencing transcript or one of them transcripts from his other case, I'm telling you, get into the mind of how he think. But that judge like literally read him. That judge knew exactly what he was dealing with and all of that. Like it didn't matter what he said. He was just like, oh, okay, you finished. Thank you so much for the scriptures. Let me tell you the other scriptures. What did one of the prosecutors was like? He keep quoting scriptures, but what about the scripture about how precious somebody's name is? She sure did. Ooh. She said, "Boop, I know the word too."
Okay. This thing is a whole mess. It's a whole mess.
It is.
And he really does think he's the smartest person in the room. It's that narcissism in him. Ooh.
Yeah, that's my son. Ignorance of the law is no excuse. I say that all the time. But I didn't know. I'd be like, honey, when you go before that judge with that ticket you got, they're going to tell you ignorance of the law is no excuse. You should have known that you should have been crossing that street like that.
In a real way.
They let you know up in here. I don't know what they doing over there at the New York parts, but. All right. So y'all ready for the last part? Yes. Who's praying for Bishop Whitehead 10 toes down?
Lord.
All right, so this is the last part. So, and then we'll So, all right, thank you. I want to raise an issue that I just want to address to Miss Lateef. Now, Miss Lateef is the court-appointed trustee over this case. There are two documents filed on the docket of case number 22-40211. One is on document number 48.3. The other is at document number 28.3. There are two different versions of a trust agreement, both from the debtor. I'm confident that there's a reasonable explanation as to why there are two separate trust agreements that are dated the same date and appear to be signed by the same party. But if there isn't a reasonable explanation, then somebody has actually committed a bankruptcy crime, in which case I need to refer that to the Department of Justice. So I wanted to put the U.S. trustee on notice because the U.S. trustee is a party in interest. If there's a possibility, not a probability, a possibility that I wanted to bring to the office's attention in case the U.S. trustee is a party in interest in dealing with discovery in connection with the motion. It's Ponder.
My bad. Yeah, and I'm glad the court has noticed that concern, because though attorneys for Glory of God and for Michael Moses were made aware of the operative documents, and I will say to the benefit of Miss Barrett that upon information and belief, I don't think she was made privy to the trust documents that you specifically Wait a minute, did I skip a line?
No, it's inaudible. You're right.
Oh, okay. Specifically, what happened is the Moses to Moses and then Moses to Whitehead and Mr. Kulaks is here. I do believe that one trust document that she did get that was Lydia Moses to Michael Moses was provided to her by Mr. Kulaks, and that's just upon information. And Mr. Kulaks can speak to whether he provided that, but certainly Mr. Kulaks, having represented Mr. Moses, was aware of the subsequent transfers of that trust, covering it to the business trust of Moses to Moses and ultimately Moses to Whitehead. These are all notarized, so we are also had, and by the way, I have emails from Mr. Kulaks to the debtor's former counsel, which support that Mr. Kulaks was aware of the...
I'm going to cut you off, Mr. Ponder.
Okay.
I'm sorry. This is substantive and...
All right.
And it is what it is.
I'll get away from the...
That's why.
I'm sorry.
Yeah, no.
But I agree.
I know you can't help yourself. I couldn't help myself.
I'm sorry.
Probably.
I'm sorry. Let me get back to that. I agree that there certainly is an issue, lack of candor. I don't know if that's a Department of Justice issue, but lack of candor is that the attorneys are filing documents to be operative documents, but failing to file the most complete document, and the debtor has of course filed the operative documents, and yes, has filed something more that is criminal. I certainly think that it needs to be looked into, but again, I'll let Ms. Barrett and Mr. Kulak speak to it. But I was very aware and very shocked that the trust documents filed to support these motions, which are on the same date, but Mr. Moses had executed the signatures and notarized, so it certainly allowed showed lack of candor. I don't know if there's any criminality here, but certainly, Your Honor, the documents that the court considers are certainly not the most recent. If you look at the dates and what the court is pointing out, 127 basically supports that this is the same trust agreement that's being basically changed by the trustees to...
I don't...
Okay.
know what you're doing, Mr. Ponder. I mean, I shouldn't have to...
You brought up a criminal issue.
I brought it up, yeah, and now you're getting...
But I'm just responding to it.
No, it wasn't directed to you. It was directed to Miss Latif. We have two different trust documents filed in the same case. One in connection with Mr. Kulak's motion, and the other, which is the affidavit that was most recently filed. And
I just wanted to put it on record, Your Honor, that I noticed that too. And
yeah.
Uh-huh. There's a.
Then you went to.
Yeah, I understand. Perhaps I commented too far, but I certainly don't know what. At what point you.
It's an evidentiary issue.
Okay.
It's an evidentiary issue. This is an issue as to whether somebody violated 18 U.S.C. 150K by knowingly and fraudulently making a false oath by filing a fraudulent document in a bankruptcy case. That's not a decision that will be decided today. That's going to be decided when we have an evidentiary hearing, all right? Let's just ask, is there any other? I'm pretty much done. But if anybody else needs any further clarity, I'm happy to hear from anybody, not argument, opposition, questions on procedures, and make sure that we have a plan for going forward on the 30th.
Brian Ponder, Your Honor. Well, no, Miss Barrett. Who's Miss Barrett? Is my Miss Barrett too? So I don't forgot.
Your Honor, Clover Beard, I have nothing further, Your Honor. All right, thank you.
All right, Brian Ponder, Your Honor. As late, I put in the court in discussion of those documents. I think the court and I made similar accusations with respect to Mr. Kulak's knowledge of the documents and Ms. Barrett's support in these documents. I think it's fair that the court hear from them on that so that my insinuations are not, going unheard. I don't want to speak about either of those attorneys if I had misstated anything regarding Mr. Kulak's awareness of these other documents or Ms. Barrett's unawareness of these two documents filed and receipt of those from Mr. Kulak for the lack of candor of Mr. Kulak to Ms. Barrett and lack of candor from Mr. Kulak to the court with respect to the operative other documents.
All right.
At the same time,
here's the thing. This is not evidence. This is just attorney speaking akin to argument, right? But we're not entertaining arguments, and there is no need to respond to anything today. If somebody feels that they need to respond, I'm okay. But it's not as if anything that's being said today is going to shock, surprise, or influence me. I'm going to make a decision and what I hear on the 30th, so no one just don't want to say I don't want to respond. If people want to respond, that's fine. Mr. Kulak, if you want to respond, go ahead. Otherwise, you don't have to. I really don't care.
Yeah, Judge, I don't mean to interrupt. I'm sitting here and I'm trying to contain my anger. Ooh!
I know.
It's just completely unacceptable. And bear with me, Judge, for Mr. Ponder to tell the court what I was aware of, what I was not aware of. And I will simply say, because this will come out at the March 30th trial, that I'm confident that the court is going to determine that there is a fraudulent document that was submitted to the court and that the appropriate action will be taken with respect to that document. Again, I don't believe the court wants to go any further, so that I will leave it at all that today and bring it out on the 30th.
All right. Thank you for your restraint. Again, it wasn't the only thing that matters is the testimony at trial on the 30th and the documents that are admitted into evidence, and I'll make reasonable inferences from whatever you give me. Okay, Miss Barrett, if you want to go ahead.
Who's Miss Barrett?
Absolutely not, Your Honor. I'm ready to. I have nothing. She ain't saying much no more. She over it.
Your Honor, may I respond? Your Honor, again, if there's any document, again, these documents are signed by Michael Moses. So Mr. Kulak represents Michael Moses. So I will say that if anything that's before the court, if there's any indication of any fraud or whether his client did not sign something, please, if he could use this opportunity to, first of all, just make me aware. No, we're not making.
Okay, first of all, stop.
Yeah.
Stop the proceedings. Stop it. 1 second. See, you can't come in here with all of this janky stuff, and you come in with this janky stuff, and then in the middle of it, you realize how janky and stupid and risky all of this is, and now y'all are in here scared because you know that you have gotten yourself into a really bad situation, right? And now you're trying to talk your way into some type of clarity, or we trying to, okay, this is what it was. No, okay, listen. My name is Thais Jackson, Your Honor, from Los Angeles, California. I think all of this needs criminal referral. Continue, baby.
Just finish that out, and then we're gonna be done with it, because child.
Okay. Because I did call him to make him aware of this. Call me and contact me so that we can get this straightened out.
Okay, and sing.
Child, now he's scared. Oh, he's scared now. He's scared now.
He said.
No. Oh.
You can't tell me that they was not sitting close to the microwaves as kids. Like y'all had somebody fell and hit the head of the child. I can't. I'm sorry.
He said, I think he was. How do you call somebody out though? You call them out and say you knew this, and you know. So basically, what he's arguing, for those who missed it, Ponder is saying, yeah, the trust document that has Lydia as the settlor and Moses as the trustee may have been the original one, but there were subsequent documents after the fact. So he was kind of, he did say that they didn't file the most recent document, and Moses and them know that there were subsequent documents that went from Moses to Moses, and then Moses to Whitehead, because you got to eliminate Lydia, because she was, she would have to be a part of it. So it was like, basically, they didn't turn in the last document. And so Moses' attorney just came back and was like, yeah, all right, I ain't even about to say all this. We about to see.
Right. I ain't even about to sit here and explain it now. You wait till the 30th when it counts.
That's pretty much what he said. And then he was like, oh, wait a minute. If you have any, now we need to meet and confer. Let's meet and confer.
Good. We don't need to meet and confer about nothing. Not a thing.
I'm not trying to.
I can actually show y'all where the signature came. One of them signatures where it looks like it came from, because I showed you the signature at the bottom. Well, child, I guess we'll see. We'll see.
I'm not trying to, infer anything on Mr. Ponder, because I don't know him personally. I've heard what people say, but my thing is this: what is the incentive, Pam, to go into a court with this type of criminal and just all of these liabilities attached to it? I understand Whitehead wants this church for whatever reason, but why would you do this? Why would you go into a court of law and risk your license and risk everything? What is the incentive, Pam? Do you know, Pam?
I would have ditched him a long time, but I wouldn't even took his case because the whole thing is, again, we all know that Ponder was looking at all of the flaws that was in Whitehead's position before, and then you decided to, represent him. We know Trump's lawyer did that too. He going through that with the Stormy Daniels. That's why he got to testify now, because originally she came to you and you was going to represent her, and you probably got information in that consultation. So now they had to go before the court to see if it's a conflict. But it wasn't like, I guess, in theory, you represented them. So it depends on how much facts was presented, I guess. So some people do that. I don't do that. Like, if people call me and they're like, hey, I want to sue so-and-so, I'm like, well, I can't do that because I represented them before. You know what I'm saying? Like, that's me. You do conflict checks. But in theory, Ponder didn't represent. Somebody asked me that in my comments. He never represented Anderson. He offered his services for Anderson. So he never represented her. Her attorney was like, nah, we don't want you on board. And then next thing you know, he was filing these lawsuits on behalf of Whitehead. And the original law, he started defending him in the Anderson case. And then he started filing them lawsuits against them, defamation lawsuits on his behalf.
And now he's just filing all kinds of crazy stuff.
Yeah. So now I guess he's just saying what happens. I don't know. He has a whole, now Whitehead does have a whole different attorney. You saw that in the transcript that's doing that whole landlord-tenant commercial. I just need, do you guys go to meetings together, go to lunch, any of y'all? Do you have a universal system somewhere? I just don't understand how the left hand never knows what the right. But then I think also the judge is smart for making sure everything is done procedurally correctly.
Mm-hmm.
Sure everything is done where there is no reason to come back. Because when you're dealing with a certain kind of person, they find loopholes, because that's what's alleged occurred in the prior case. They were trying to say that he found some type of discrepancies and there was a technicality. I don't know. I've never seen it, but that's what's being alleged as to why he got out early. And then there's been other cases I've seen that he's lost, and when they asked for attorney fees, it was denied. And it was like, why? We don't think it's frivolous. Like, what? You know what I'm saying? So that's why I'm saying that I think that this judge she's not dumb. So she probably is reading over everything. And the fact she brought up the documents, Ponder wanted to stay on these documents. Like he wanted to see like what information was going to come out. But you relied on your client. Your client gave you this information. You just wanted to rely on them and file it. Then, I mean, you just going to have to go with what it goes with. And hope that you don't get the bam, when that 30th comes. That's all you can do if you decided to file that.
Good luck. I wonder if they're gonna show up on the 30th.
I don't know.
I don't know. They need to though, because this is about to be a whole situation.
Baby, listen.
That's a good question.
Are they gonna show up? I would show up. I would go.
You stay home that day?
Baby, I wouldn't go. I wouldn't be in that situation in the first place because I wouldn't put myself in that damn situation.
Wow. Joyce said Lydia and her sons will be there. Could you email me, Joyce? She says she's Jawan's aunt. Jawan.
Okay.
Aunt. Could you email me, please, Miss Brown? Wait, didn't SDNY have a search warrant looking for guns in the church? That makes me further think this church is the front for something. I don't know.
That's a lot to put in a. That's a lot to put in a Andre. That's a lot to put in somebody's chat.
You're trying to get us sued.
my God. That's a lot. A lot of tea to spill in the chat.
It's in my description, but Ken, I think I got mine. You can tell my husband is out of town, so that's why he ain't in the chat. But if your mom could just put my email address
in the chat.
Put my email address in the chat for me. It's in the description though, but if you put it in the chat.
So yeah, this thing gonna be a whole fool this week. I wonder now. So what are the predictions, y'all? Do y'all think he gonna go live on Tuesday or Wednesday? And you know how he get nervous before court. You know how he go live and he be, y'all think we're gonna get you think we're gonna get a somber pray for the bishop live, or we're gonna get a I'll box you right now, right here, everywhere in the place live? Yeah. Are we gonna get a somber in the office live, or we're gonna get a car rah-rah live? What y'all think we're gonna get this week, y'all?
Well, tonight you're gonna get Shirley Caesar and Fred Hammond.
Yes, we're gonna get
Shirley Caesar, Fred Hammond reading the Bible. Monday, Tuesday may be kind of slow. Then on Wednesday, he's gonna get real agitated and he's gonna find anybody, Kirk Franklin, D.L. Hughley, somebody, just to latch a hold to let his frustration out on, because that's what he does. Like whoever he's beefing with, he beats with them hard when he's agitated and scared, right? So Wednesday night is gonna be something's gonna come up. Watch. Why are you breathing?
It's a lot going on this week.
By himself.
He got the Connecticut case. It's a few cases going on this week. So y'all know I'll be in New York on Tuesday.
Don't say too much, Pam. Don't put too much out, Pam. Birds picking up seeds.
Looking for you.
Yeah, Pam. Don't put out too much information. Remember, you said you was going to North Carolina. Remember?
Oh, that's right. Yeah, I'm in D.C.
You know.
Yeah, come on to DC, girl. Come on to DC.
Child.
Listen, that
you gotta use.
Suge Knight. He might get Suge Knight, like big boy that came up there to that church. Thomason, call your boss. Who says so? Whitehead. Call your boss. I'll be like, all right, sir. You know
that was gangster. He said, call your boss, sir. Shut that thing down now. Listen, I might not like what happened, but the way it happened was real gangster. He said, call your boss.
It was. I was like, and they said they're like, we have an order. They was kind of like, he like, man, forget you wearing your order. Call your boss, buddy.
Right. He was like, go out of here with
y'all wild over there
get out of here
in New York. Y'all wild over there in Brooklyn, man. I don't know.
Yep. Baby, listen. They say it goes down in Brooklyn.
March 28th for the Connecticut case, his continuance was denied. Look at that. I wonder if they still doing it on YouTube where you can watch it, because we was watching their hearings on YouTube.
Ooh,
thank you so much for the update. Oh yeah,
send me the link.
You said we need to see if this will be live streamed. It's not in I know bankruptcy court isn't. None of the federal courts live stream anything.
When you said he looked better without his glasses, the next day he came on without. He do, and that's no shade. Take them glasses off. You do look better without your glasses. Take them glasses off. You know. Stop, y'all. Y'all not gonna worry me.
Don't worry about it, Pam. We'll be good. Yes, we are in Brooklyn. Okay, child. Yeah, email me, because I'm gonna need my Brooklyn fam to surround me, because I don't want no smoke. I got a couple cases in New York. I'm trying to pave my way. I don't want no smoke over there.
It depends on what part of Brooklyn is.
It depends on what type of stop talking about Brooklyn. Oh my goodness, was that like what was that last part? Was that like a
Oh my goodness.
Brooklyn? Like what you talking about?
We know a lot more fake documents. But that's the accusation.
You said yes, it's remote. So you guys on the 28th, you guys can watch the hearing. I might post the link to my wall. Maybe that's what I'll do. Because I think I got depositions that day. I might miss it. So I need somebody to be a very good scriber and tell me what happens in that hearing.
I don't know if I can be a good scriber, but yeah.
It's gonna be a glorious day.
As best as I can be, I'll be as I can be. I'm gonna be at work, but I'll be in there as much as I can be, honey.
Oh my goodness, y'all! I wasn't trying to be gangster like that. I don't need backup like that. I just was like, trust me, I ain't going by myself now. I ain't from there. I'm from Detroit, so I already know how it was good. So I'm fine. I was just saying that y'all, it's okay.
Why is the food if we're not okay, Lorraine? Did nobody say nothing? I didn't hear nobody say that about Brooklyn. That's why I say people hear what they want to hear. Nobody said that about Brooklyn. Nobody said that about Brooklyn.
Gee, I wasn't trying to offend my Brooklyn subscribers.
What nobody said that about Brooklyn, baby?
It's all good, y'all. It's all good.
Listen, right now, every city got a little action. Nice neighborhoods, and every city can get a little gangster. Beverly Hills is off the chain right now.
Yeah. So y'all know how. Let me do my little intro again. Then we gonna end with the bishop, and then we gonna be out of here.
Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest. Not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because their agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Oh my God, I love that, Pam. I wasn't here at the beginning. That was nice.
Thank you. Look, y'all dancing. I'm telling my son y'all think it's lit.
Yeah.
He did that. All right.
It's always fun with y'all when we do this. So
yeah.
I look forward to this.
Well, I enjoy y'all. We'll be back soon. Thank you all again. Really be let them know where to find you at.
You can find me at Really Be TV on YouTube. We over there. We have a good time. Y'all come on over and hang out with us sometime. I'm 4 subscribers away from 1,100 subscribers.
Get it, girl. 10,000. 11,000. That was quick.
So yes, honey. I know, girl. It's that. Listen, it's that Escape SWV. I ain't gonna lie to you, baby. Y'all can't get enough of that Escape SWV, honey.
Yeah, she got that good commentary.
And you can find me at the official Thais Report right here on YouTube, the official Thais Report. I have a show coming up tonight at 6 p.m. We're covering, it's a double header on Revisited tonight. So if you want to stop by, it's a double header. We're going to be talking about Paul Williams' suicide. And we're also going to be talking about Tito Jackson's wife's drowning. So we got a double header.
That's a good one.
Okay.
Yeah.
We have a lot of questions. Yeah, it's a double header tonight.
That's 9 o'clock Eastern Standard Time.
Well, I'm gonna have to slide over there after my live. I'm gonna slide over there after I get off my live because that is a good. Paul Williams was always a sad one to me, but that T. Jackson's ex-wife, ooh, that's a good one.
The man said she can swim.
What?
So somebody said she can swim. So I don't know what happened. We'll get down to the bottom of it tonight.
All right, y'all. Thank you for joining us.
Verified award.
See, now really be want to discuss this. We're gonna head on over there.
I know.
I'm almost at 7,000 subscribers, Pam. So coming on your platform has helped get those numbers up too. So I'm at 6,800 plus, and I'll be at 7,000 very soon.
Congratulations. Y'all go over there and make sure you subscribe. Subscribe here if you haven't done so already. And until next time, we holla at you later.